This is a lecture from Open Tuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
This chapter deals with employment law, and this also covers some aspects of bribery, corruption, facilitation payments, dealing with money laundering problems and whistleblowing, some of which we've mentioned a little bit earlier. And towards the end, it looks at the duties under data protection legislation. But first of all, what's meant by employment? When are you an employee? And this hinges on whether you are regarded as having a contract of service, that's when you become an employee, or whether you simply have a contract to provide services. So, for example, if I wanted to have let's say my bathroom refitted and I hired a plumber for a week or something of that sort, then that plumber does not become my employee. This person is really entering into a contract to provide plumbing services. There are quite complicated rules about deciding whether it's a contract for service or services. It's principally to do with taxation, because the taxation of employees and employees and self-employed people is really quite different. When you become an employee, you expect to have terms of employment. You don't necessarily have to have a written contract of employment, but many people do, obviously. And those terms can be set out in the contract. They can be set out in the engagement letter that you've been sent. It could be a verbal arrangement. It could be the employee handbook, which sets out holiday and sick pay arrangements. But sometimes the law will intervene. Many countries have laws setting out the minimum wage rate, or laws setting out the maximum hours you're permitted to work in a week. In the UK, even if there's not a formal contract, you have to be provided as an employee with a written statement of particulars, like the employer's name, your salary, your pension entitlements, the notice period, whether or not it's a fixed term contract will end in 2 years, and so on. There's a full list of this in your notes. There are implied terms in all employment contracts. For example, it is required of the employer to behave in such a way to maintain and the employee as well, to maintain mutual trust and confidence. So if either party acts unreasonably to undermine mutual trust and confidence, then the employment contract might be broken. And we'll see there's something called constructive dismissal, whereby you can sometimes regard the behavior of your employer as being so outrageous that it completely undermines the employment contract, and effectively you regard yourself as having been dismissed. There's a duty of fidelity. This is this kind of honesty really by the employee to the employer, not to spill the secrets of the employer, to act in the best interest of the employer. And this becomes particularly contentious when you change employer, because at your old employer you will know about their products, you know about plans for new products, you'll know about their customers, you maybe know what prices they're paying to their suppliers, and when you move to the new employer, you'll take all of that knowledge with you, and of course there is a danger you begin spinning the secrets of the old employer. Believe it or not, there is a duty not to steal from your employer. Didn't say much more about that. You should obey the reasonable and lawful instructions of your employer. So people above you, called supervisors or managers, there is an implied part of your contract that you'll do what they say, provided it's reasonable, provided it's lawful. Employees must exercise reasonable care and skill. Now, what is reasonable care and skill depends very much on what you are and what your qualifications are. So if you are qualified as an accountant, then the reasonable care and skill with regard to maybe preparing estimates and budgets will be higher than what it might be expected from somebody who has got no accounting training. Employers are required to provide a safe working environment for their employees. We'll see much more about this when we come on to looking at health and safety. Employees should supply what's necessary to do the job in certain circumstances. So if you are let's say, a delivery driver, then it is an implied term of the contract of employment that you have a driving license. There is not normally a duty on the employer to provide work. So let's say somebody is paid on a kind of variable rate. They're only paid maybe when they do some work, something called a piece rate. You are paid per item produced. Slightly old-fashioned now, but it's still possible. And let's say in a particular day the employer does not require you to produce anything, and therefore you're not going to be paid. There is no particular duty on the employer to still pay you or to provide that. The only time it becomes a duty is if really to keep your skills up and your reputation up. Maybe you need a certain amount of work to be doing that. There is no duty upon employers to provide references if you're seeking new employment. And many employers prefer not to because it's rather time consuming. They can get into potentially legal difficulties, because if you do choose to supply a reference, then you have to make sure it's accurate. If it's not accurate, the employee could potentially take some action against you for ruining their chances of re-employment. Now, in the UK and in much of Europe, there is a considerable amount of legislation dealing with discrimination and outlawing discrimination. And in the UK, we have laws now which essentially outlaw laws to do with discrimination, either on hiring people or paying people or promoting people, based on the grounds of race or sex, whether it's male or female, disability. In the UK, reasonable adjustments have to be made to the working environment so that disabled people can be employed. This would put a higher burden on a very large company. A very large company would expect to put in a lift to allow wheelchairs going up. If you were a very small company, say 2 people in it, and you were hired officers on the first floor, then it would be regarded as probably being unreasonable to expect you to put in a lift if you were taking on or wanted to take on one disabled person. We can't discriminate in terms of religion or sexual orientation or age. Now, the 3 types of potential illegal behavior arising from discrimination are as follows. First of all, you can have what's called direct discrimination. And this would occur if you put an ad in the paper saying salesman required, because you're implied that you don't want any women to apply for that job. That is direct discrimination. That's usually fairly easy to spot. By the way, you can sometimes get away with a little bit of discrimination if it is absolutely inherent in the job. So if you were advertising for actors to play Romeo and Juliet, you would be permitted, as things are at the moment, to insist that the person playing Romeo was male and to insist that the person playing Juliet was female. And there are a few other very kind of exceptional rules on discrimination. Indirect discrimination is harder to find or harder to maybe recognize in advance. So if you put an advert in the paper saying salesperson required, and then said that the person must be 2 meters tall with a large black beard, then effectively there's indirect discrimination there, because it is relatively unlikely that female applicants will be able to comply with the condition that they're 2 meters tall with a large black beard. And this is where many organizations inadvertently fall into discrimination. For example, there was a case in the UK where within a company, people were going to be going on to some sort of fast-track management course, and it said to be eligible for this course, you have to be under the age of 30, and you have to have been, let's say, a supervisor for 3 years. And that was held to be discriminatory against women, because many women have to have time out to have children. So around the birth of the child and afterwards they have maybe a year off, something of that sort. So it is much harder for women and men to be 30 and have 3 years supervisory experience, because they simply haven't had the time to do that. So there was it wasn't deliberate, direct discrimination, but it kind of sneaked up on people as being unfair. And then there is victimization. And victimization is what happens if an employee takes their employer to what's called an employment tribunal. This is where these discrimination claims are heard. And the employment tribunal finds on the side of the employee, and then the employee kind of goes back to work, goes back to work, and then people are nasty, if you like, to that employee because they're taking the employer to the tribunal and give them a hard time. That is victimization, and that in itself is illegal. The idea of diversity in employment is something which people have really encouraged now in the UK for the last 10 to 20 years. And diversity is where you try to have employees that match the composition and makeup of the population as a whole, rather than just, for example, in a company going for white, male, university, maybe public school educated people who are maybe like the existing managers. Diversity is saying, no, that you don't want to do that, apart from there maybe being discrimination in it. But even if it wasn't going over the discrimination laws, you don't actually want that or shouldn't want that. What's the point in having more people the same as you is really what it's saying. And the thrust against having this kind of monoculture and trying to encourage diversity is you simply get a wider range of candidates. If you simply say, I just want male candidates, you're cutting out half of the population, which is silly. Or if you are in a way saying, I want all employees to work conventional working weeks 9 to 5 days a week, then of course you could be making it very difficult for parents. And many parents might want to work 3 days a week, and maybe they want to work 5 days a week, but they want to leave work at 3 so they can pick their children up and so on. If you don't offer that flexibility, again, you could be turning your back on an awful lot of talented people who maybe used to work for you and were very good, but now other commitments mean they can't. So diversity will widen the pool of candidates. It'll give you a greater range of skills, not just technical skills, but social skills, getting on with a wider range of people. It matches customers. You would feel perhaps a little bit intimidated as a customer if the people supplying you with the goods or services were very different to the people you regard like yourself or people you are used to. So to make your customers feel more comfortable, diversity is probably a good thing. And of course there are going to be reputational advantages. Once you get a reputation of being an open and fair and diverse employer, you will probably attract better candidates and you may attract a whole extra range of customers. So apart from any kind of moral or ethical push, if you like, to encourage diversity, you can justify it very much in terms it will almost certainly increase your profit and improve the quality of people who are working for you. Bribery, corruption and whistleblowing. If you remember, we talked about this a little bit in ethics. Bribery is giving some sort of financial inducement to someone to do something they shouldn't do. So it could be a customs officer, and you pay the customs officer to push goods through the import system without raising the proper taxes and duty on that. That is bribery. Facilitation payments, sometimes called grease money, is where you pay somebody to do more quickly or more efficiently something they should be doing anyway. So your goods come to the front of the queue for customs. Both of those in the UK are regarded as illegal. So these are illegal acts and you must not do them. Whistleblowing. Whistleblowing can be, as it's defined here, making a disclosure that is in the public interest. It is an employee seeing something wrong in their employer. The employer doesn't worry about it, covers it up, repeats it, and so on. And you are convinced that this is wrong. This is against the public interest in some way. In the UK, employees are given protection if they embark on whistleblowing, provided certain things are in place. First of all, you have to be whistleblowing about, say, a criminal offence. Or, if someone's health and safety is in danger, you are allowed to whistleblow. Or if there's a risk or actual damage to the environment. So if, on the quiet, your employer is releasing nasty stuff into the river, then that would be grounds for whistleblowing. If you think there's a miscarriage of justice, you think your employer's got away with something that they shouldn't have because they've told lies, maybe during a court case. If the company is breaking the law, if the company isn't paying its correct taxes or is making people work far longer than the law requires them to, then you'd be allowed to whistleblow. Or you believe that someone is covering up a wrongdoing, then you are allowed to whistleblow. You're allowed to divulge this information to the authorities. However, it has to be done basically in good faith. It must actually be in the public interest. So to be protected by law, the whistleblower must believe what they are saying is basically true. They're not making it up. It's not a malicious invention, if you like, just to get your own back on your employer because you didn't get that promotion you were hoping for. You must reasonably believe the information to be substantially true. Again, to get away from just stirring up problems in revenge or maliciously, something of that sort. And you must reasonably believe that you're making a disclosure to the right person. And that would tend to mean that you can't go off immediately to a newspaper. So usually within the company, there might be people that you could report the wrongdoings to. If the company doesn't take any action, then maybe you go and seek legal advice, or you go to your CIMA, your professional institute, and so on. And really, only as a last resort would you tend to be justified in saying, well, the only proper disclosure I have left is publicity, maybe going to newspapers or TVs. Money laundering. Money laundering is where a company or a person tries to conceal the source of funds, because the source of funds is essentially illegal. It's from drug money, prostitution, people smuggling, whatever it's going to be. And what we want to do is to conceal these proceeds, but nevertheless make it look as though they have a legitimate origin. I mean, obviously one way you could conceal proceeds is just to hide it, but that's not going to give you much pleasure. What people with these drug money want to do, they want to spend it. They want to spend it on flashy cars, usually. And what money laundering does is it tries to clean it. It is basically cleaning. It's dirty money, but we want to make it look as though it's legitimate income. And the three processes here, first of all, this placement. In other words, you try to convince people this money has been earned legitimately from a legitimate business. Businesses based on cash are very suitable for this, and the sort of businesses that have been used in the past for money laundering are things like taxi businesses, because of course most people pay their taxi fare by cash, and maybe a taxi driver or a taxi company, maybe its earnings in the week from a taxi company is 30,000. They just bump it up to 40,000, and the extra 10,000 is them kind of bringing in the money from the drug trades. Another place is casinos, because again, casinos is pretty much a cash business. And all you say, well, I didn't just win 20,000 from these gamblers. Actually, I won 30,000 from these gamblers. And again, an extra 10,000 is banked. Now, of course, when it's banked, when it's part of a legitimate business, it's going to be taxed. But these people say, well, that's a cheap price to pay, to be able then to spend it, without any suspicion. 20% is lost on it, 30% is lost, but the other 70 or 80% now is something which I can maybe begin to spend safely. However, having got it into a legitimate business, people are still not quite satisfied, because if the authorities can at some point prove that it came from an illegal business, they can grab this money off the person. So what we then usually embark on is a process of layering, which is where this money, ostensibly from a legitimate business, gets paid into one bank account, out of that bank account, into another bank account, paid abroad, various bank accounts abroad, etc., etc., etc. So that the money trail, if you like, is very much concealed. So it's going to be very hard later on for the authorities to say, this £10,000 came from that, because it's gone through all of these confusing kind of processes in the middle. And that's layering. And then finally, we have to bring it back again. We have to get it integrated into the economy. So if you've passed it around all of these banks, and maybe it's ended up abroad, what you want to be able to do is to say, well, this money has now come from abroad because I've sold my villa abroad, and this is just the proceeds coming back. And then these people feel they can spend it freely and safely without any risk of it being grabbed back by the authorities. Now, if you have suspicions of money laundering in the UK, and the emphasis here is not on proof, the emphasis here is on a suspicion, then this should be reported to the authorities. It doesn't mean immediately as an employee you go and ring up the police. Businesses should establish, firms of accountants establish what's called money laundering officers, people who are responsible where your fears about money laundering should be kind of passed through, and this person then, takes a more skilled view perhaps on whether it is money laundering. You also have to avoid what's called tipping off. So if you're out doing some sort of assignment with a client, some sort of consultancy assignment, and you see something that looks like money laundering, you can say to this client, by the way, I'm reporting you to the authorities because I think it's money laundering. That's tipping off, because of course this person is immediately going to take kind of emergency action to conceal even further the money laundering activities.